My name is Dr. Eboso from Vihiga County, and I'm petitioner number 11 in the consolidated petition in the cohort 1. As I sat as a petitioner who essentially had no issue with the sitting of the bench, because when a petitioner files a petition, there is a presumption that the bench is properly constituted and that Kenyans elected the Constitution of 2010, and in it provided the independence of the judiciary and the conduct of the expected conduct of judges. And therefore, we as Kenyans have trust in the judiciary and the individual judges at the time when they are appointed and during the course of their performance of functions. But as I sat, I agonized over the issues that have been raised, and at the outset, I realized that the recusal application has been made to this bench to recuse itself, or some of the judges to recuse themselves, but as a decision of the bench. And I agonized over whether recusal or the place of recusal proceedings in a setup like ours. And perhaps this was amplified by the back and forth that we saw with regard to the facts that were coming out. And I would wish to be persuaded by Dr. Haminwa that really recusal proceedings and the kind of facts that come to light ought not really be a subject of litigation for several reasons. One, recusal proceedings are really against individual justices, and they relate to the personal conduct which really lies in the mind and conscience of the individual judge. I would give an example. Suppose we ask the bench for one of the judges to recuse themselves, and two of the justices disagreed with the recusal, but the very judge who we are asking to recuse themselves. Would we then say that this bench has ruled that the judge must sit? So it's really an individual decision of the judge to reflect upon the facts that are before him, the relationship that is being alleged, because why it can't be litigation, and it should be in the interest of all the parties that the judge is not biased, such that when you make it litigious, what happens is one side will be claiming the other side must prove a point, which they are not really very materially cognizant of. And it's really just the judge who knows the actual facts of the issue. And so it really is upon the judge individually to look at themselves and ask themselves whether the facts that are being alleged constitute what would amount to a bias. And when we make it litigious like this, we actually violate the Constitution for the reason that the conduct of a judge is not meant to be subject of any proceeding before a court. That is a matter that should be before JSC, that should be before other tribunals. And the Supreme Court has told us that in Bellevue, that the conduct of a judge, because that's what is being alleged here, a judge is being alleged to have concealed information that they ought to have given. A judge is being alleged to have abused office by sitting on a particular day and whatnot. So those are things that really should not be a subject of a proceeding if we really intend to proceed with this matter. Suppose this bench does not recuse itself, then how does the matter proceed in that manner? I'd like to point out that I think I've already talked about the fact that the facts relating to a recusal, the person who really knows what those facts are and the extent to which they are is the judge. And so any discussion as to whether we've proved a case or not proved a case is neither here nor there as relates to this issue. I'd like to refer the court, I don't know how we quote precedents, but I'd like to refer the court to a decision of the Supreme Court of the United States in Jewel Ridge Coal Corporation versus local number 6167, United Mine Workers of America in 1945. And there the court, the Supreme Court, found that I think one of the parties was asking for the entire bench to recuse themselves. And I'll just take maybe one more minute for the entire bench to recuse themselves. And the Supreme Court of the United States found that that decision cannot be made by the bench. A question of recusal should be directed at the judge, and it should be the judge to make the decision whether we themselves will recuse themselves or not. It was also, again, captured in 1980 in a decision called Hanrahan versus Hampton, still at the United States Supreme Court. And in India, in 2016, Advocates on Record Association and others versus Union of India. Justice Madan also pointed out the same. And finally, I'd like to refer the court to the fact that this is a sensitive matter, but it's also, as sensitive as it is also an urgent matter, as considered by the bench and as considered by everyone. That there is the aspect of necessity that this matter must be heard. And there's also room for appeal should any person feel they are aggrieved by decisions of this court or the judges herein. And so what I would say is that I would ask that the individual justices, that you look into the issues that have been raised, you look into the facts which you are familiar with them yourselves, and go home and reflect whether indeed you will have the impartiality to hear this matter. And once you make that decision, let's hear the matter and proceed. Thank you.